Good afternoon, everyone. This is Scott Reisch from Crime Talk, the voir dire podcast, but we are specifically dealing with crime issues this week as we have been dealing with the Christopher Watts matter. Christopher Watts was the gentleman up in Weld County, Colorado, who had been charged with killing his pregnant wife and two young daughters. And now we don't have to say allegedly. He is guilty. He pled guilty. Case closed. But what does this mean? What did he plead guilty to? How do we know if it's a good and valid plea? When's he getting sentenced? Let's talk about it. He pled guilty straight up to all 9 counts in the complaint and information. So he's got first-degree murder, count 1. First-degree murder, count 1. Murder in the first degree, count 3. They dismissed count 4. He pled guilty to that one as well. First degree murder. He pled guilty to tampering as well as unlawful termination of a pregnancy. So Mr. Watts pled guilty. What's the big deal? He pled guilty 1 count of murder here in the state of Colorado. That is life without parole. What does life without parole mean? It truly means life without parole. He will never get out of prison. He now has 3 life without paroles, plus unlawful termination of a pregnancy, which is an F2, which is 8 to 24 years. It could be aggravated as high as 48. And the tampering are F3s, which are 4 to 12 for each count. So you can do the math. He's going to get stacked up pretty high, but it really doesn't matter. In reality, what it means is Christopher Watts got a volume discount on crime. The district attorney made the offer to Mr. Watts to plead guilty, basically straight up to all of the counts, so that he would avoid the death penalty. Was he an honorable man, or was he just a wimp, so to speak? It doesn't really matter. He had made a statement whereby he said he killed his wife, but he didn't kill his daughters. Well, he pled guilty to killing his daughters today, and that is over. What takes place when Mr. Watts pled guilty? I had hoped that I was going to be up there today, but unfortunately, I had to be in federal court. So what's the next best thing? If you can't be there, you send an associate. So I sent my associate up there, and he sent me some snapshots from his phone where literally the circus was in town. All of the news agencies were up there. All of the TV press was up there. The press was literally hanging out by the door trying to listen in because they could not get in. It was packed. And then, so what did he do inside? Well, when someone pleads guilty, it's not just how do you plead guilty. No. Before the judge will accept his plea, the judge needs to be absolutely certain that Mr. Watts understood what he was charged with, what he's pleading guilty to, the rights that he has, the rights that he gives up, and the possible penalties. And the judge would do that for each count. The district attorney would outline the elements of what they would have to prove beyond a reasonable doubt to Mr. Watts, and Mr. Watts would have to acknowledge that he, in fact, did understand those rights. So let's take that for an example. And what we're trying to do here, ladies and gentlemen, we can tell you, hey, he pled guilty, that's it. We're trying to give you a little more information that you're not going to get from the local newscaster who doesn't know the difference between an initial or second advisement and an arraignment. So this was technically, it turned into an arraignment. And I called it last week when they scheduled this plea. They set a status conference date for the 6th. They didn't say what it was. It wasn't planned, but yet I told you that date was cleared by all parties, so something was up. Could have just been scheduling. I had a gut feeling they were going to take a plea. And so when he takes the plea, the judge will go through this colloquy, and he will ask Mr. Watts, do you understand what you're charged with? And most judges will read the charge. So for example, in count 1, Mr. Watts, it's alleged that on or about August 13th of 2018, Christopher Lee Watts unlawfully, feloniously, after deliberation and with the intent to cause the death of a person other than himself, caused the death of Shanann Watts in violation of Section 18.3, 102, paren 1, paren A of the Colorado Revised Statutes. And so the judge would then say, these words have various meaning and effect. Obviously, they have to prove that you did it, Mr. Watts, not someone who looked like you, not someone using your identity, but you. That it was unlawful, which means you had no legal permission or justification to do it. Feloniously simply means that it is a felony, a serious crime in the state of Colorado, and it carries a possible penalty in the Colorado Department of Corrections. After deliberation, the judge would define that with the intent to cause the death of another person, cause the death of Shanann Watts. The judge would ask, is that what happened? He should have said yes. Okay. Eventually, we'll be able to get the transcript of it since the court did not allow video in the courtroom. Once this hearing was set, the media asked for expanded media coverage, and the court denied it, citing to Colorado Supreme Court rules, which only allow enhanced, expanded media coverage when there is an advisement, like what we saw when Mr. Watts first appeared in court, and then when the actual trial exists. So pretrial, nothing else. So pleas aren't there, motions, hearings aren't included. So the judge would have gone through all of that. Then the judge would have said, before I can accept your plea of guilty, I need to make sure you understand your rights. Do you understand that you have a right to plead not guilty? He would ask Mr. Watts. Do you understand that you have a constitutional right to make sure that the prosecution can prove their case beyond a reasonable doubt, that he can make the prosecution prove each and every element of the charge beyond a reasonable doubt unanimously to a jury of 12 people? If the jury was not convinced, they would find him not guilty. At a trial, he would have a right to assist his defense attorney in picking a jury. He would have a right to cross-examine witnesses through his attorney. He would have a right to subpoena and call witnesses in his own defense. If they wouldn't come voluntarily, they could come via subpoena. And the court could pay for their costs if he was in fact indigent and couldn't afford to pay for that. On top of that, the court would then advise him, do you understand that you don't have to do anything, that you don't have to present a defense? It could be general denial, it could be alibi, it could be somebody else did it, something along those lines. At a trial, the judge would make sure you understand that you have a right to testify. It's an absolute right. Mr. Watts would make that decision, not his attorneys, not anybody else in the courtroom. It would be his decision. The judge would advise him that if he were to testify at trial, that he could be cross-examined like any other witness and receive questions from the jury. Colorado is one of the few states that allows jurors to ask questions of witnesses in a case. He would also advise him that if he went to trial and he lost, let me take that back. The judge would also tell him that if he chose not to testify, that if his defense attorney requested the instruction, that he, the judge, would give the instruction that the defendant is never compelled to testify and you cannot consider that in any way in determining his guilt. It's the absolute right to remain silent. And then finally, the judge would say that if you went to trial and you lost, you would have a right to an appeal. But when you plead guilty, you give all those rights up, except for your right to have an attorney at all stages of the proceedings. So obviously, he has pled guilty. The government doesn't have to bring witnesses to prove their case. There'll be no jury, so there'll be no selection of it. There'll be no witnesses called, so there'll be no cross-examination of the witnesses. There will be no decision of whether he testifies or not, and there will be no appeal in this particular case. For lack of a better term, when he goes to sentencing on November 19th, he's going to get multiple life sentences plus probably about 80 years, and the case will be done. Mr. Watts will go there. And you say, well, why do they go through all this information? Why do they make sure that the judge makes sure that he understands what he's doing, that he understands his rights, the penalties to be imposed, and the rights that he's giving up? The reason he's doing that is simply because in the criminal justice system, we do that. We make a transcript of it so that Mr. Watts doesn't go down to DOC and suddenly realize, hey, you know what? These guys in here don't like people that kill small children and women, and they beat me up every time they get the chance. I liked it better in county jail. I think I'll go back and withdraw my plea, or I will say that my attorneys were ineffective. And so the judge will say, no, I was there. I asked you questions. You were aware. You're not under any medications. And if you were, it's not affecting your ability to understand what's going on here today. And it was a knowing, voluntary waiver of your rights, and you voluntarily pled guilty. Completely eliminates that guess of, gee, well, maybe there's something there. And so that is it. But I don't think Mr. Watts is going to have a good time in the Department of Corrections because people in DOC, there is a hierarchy in any prison system. And people that abuse children, people that kill children, people that abuse women, people that kill women are the bottom of the barrel. And they will never, ever let him forget that. And just when he thinks that things are getting to normal, maybe 20, 30 years from now, someone will remind him that he is a baby killer and he will not enjoy it at all. And so, jumping back then to the plea, that's what would take place. Very simple, but it's very important. We want to avoid that buyer's remorse. Now, what's the positive of Mr. Watts pleading guilty today? Well, it provides closure to the family. That's a good thing, all right? The family does not have to deal with this anymore. They'll always have to deal with the repercussions that their, daughter, sister, is killed. Their grandchildren will never be around. They'll always have to deal with that, but they won't have to go through the spectacle of a trial, the circus that's going to come with this. And on top of that, Mr. Watts doesn't get to become a superhero, become infamous, have a fan club. So that's another good thing. Now, I'm a little surprised. They were probably talking death from day one. I don't know the circumstances, but my guess is the district attorney said, here's an offer. It's good for X number of days. If you take it, we'll pull it off the table. My guess is they wouldn't pull it off the table, that they would, in fact, let him plead guilty to life at some point just to avoid any risks of unknown. But the district attorney did it, and he accepted it. I don't know if that's an honorable thing to get it done, or do you fight it and the defense hardly even had to work. They pled straight up guilty, but they must have felt very concerned that he had a very good chance of being convicted by a jury in Weld County of death. So never going to second guess a defendant for doing that. I'm not going to second guess his attorneys for letting him do that, particularly on the case. It's ultimately the client's decision. The attorney just simply advises of the options that are available to him. Now, the report that my associate also gave me up there, and I obviously haven't seen it, and I haven't seen anything on the news since this all just was breaking, but apparently Mr. Watts, when he was let out, also had on flak jacket, some body armor, as for concern for his safety, obviously, that someone may try to do harm to him. So fortunately that didn't happen, but I assure you he will not get body armor when he is in the Department of Corrections. The other unfortunate thing here is that we may never know the exact circumstances of what took place in that house up in Frederick. We have the affidavit, we have his statement. We should ultimately be able to get the coroner's report to determine cause of death, any other specific injuries, but we're never going to have the circumstances. We'll never have the actual why. Was it because Mr. Watts was having an affair and he wanted to get rid of the wife and kids and start anew? Did he just lose it that night? Was he always like this? Who knows? Was he, killing small animals, setting things on fire? Who knows? We'll never know for sure. But bottom line is, ladies and gentlemen, that case is basically over. We'll keep in touch on it through the 19th. We'll see. And obviously, if something terrible happens to Mr. Watts in the Department of Corrections, we will also let you know. So the next question then becomes, and please leave your comments, what cases would you like us to follow and comment on? And like I said, the goal of this podcast, this YouTube channel, is to provide information that you're not going to get on your local news channel that is more concerned about what happened to the professional football teams on Sunday and doesn't know the difference between the legal terminology. So we would provide insight for that. I saw a horrific case today. It looks like it just happened. A young man was accused of killing a mother and 3 young Girl Scouts today. May have to follow up on that. If you have any other suggestions, please leave them below. We will follow. We will comment. There's always something going on in the news for law and order, justice issues, crime issues. It never ceases to amaze me. It's absolutely terrible how many other things, bad things that other people can do to other people, but we will be following that. We look for your comments, suggestions. We will be here for you. Thank you very much. Thanks for listening. And Mr. Watts, case closed.